Hi, everybody. Welcome to today's video. Today, we're going to go over Harvey Adelson's answer to the amended complaint. So his previous motion to dismiss this federal lawsuit was denied, but the actual order is not publicly available. So can't show you that, but let's see how Harvey responds. First thing is that when you respond to a lawsuit, all you have to do really is to admit or deny the allegations. So you don't have to tell your whole entire story. But the first thing is, it's kind of weird that he denies the first sentence, which has to do with jurisdiction. So switching back to the actual amended complaint, plaintiff said this is an action to recover monetary damages for unpaid overtime wages under U.S. laws. So why would he deny that? That's just kind of like a statement of fact. This court has jurisdiction pursuant to the Fair Labor Standards Act. So once again, it's kind of weird that he's just denying that because those are just general statements, what the plaintiff is alleging. But anyway, let's move on to the next one. Second one is that the plaintiff is a resident of Dade County. He's a covered employee for the purposes of the act. So that, of course, Harvey does not agree with. But here he says he doesn't have sufficient info regarding that sentence. Therefore, it's denied, or the rest are denied. He admits that 519 LLC is a Florida limited liability company. He denies the rest of the allegations, which is what that as a place of business in Broward County within the court's jurisdiction and at all times material defendant, which is the LLC, wasn't it's engaged in interstate commerce. So of course, from previous filings, Harvey does not agree. Let's see here. So he admits he's an owner an officer of the corporation. He says he doesn't know enough to admit or deny number 5, which was this. All the actions raised in this complaint occurred in Broward County, Florida. Okay, so that sounds reasonable to respond that way. This is a whole list of paragraphs where Harvey is just denying every single thing from number 6 through 19. So let's see what was. Okay. So this is the complaint where plaintiff says he deserves overtime compensation to damages costs and reasonable attorney's fees for more than 40 hours per week after January 2021. The corporation was a property management company engaged in interstate commerce. The defendant is a property management company, had more than 2 employees recurrently engaged in commerce. This again sounds kind of strange, but it says that they used electronic devices to authorize credit card transactions by ordering products and supplies produced out of state. So there's enterprise coverage. He claims he was employed. He was a maintenance employee, that he was employed October 15, 2008 to June 15, 2022. More than 13 years, but for this purpose, his relevant employment period is 74 weeks. Plaintiff was hired as a handyman, paid $900 per week. He worked 5 days per week, 8 to 6. After 6, he was permanently on call, attended emergency calls, had no bona fide lunchtime. Plaintiff worked for more than 40 hours every week, but he didn't get paid overtime. Okay, plaintiff did not clock in and out, but defendants could track the number of days and hours that he worked. This I find kind of strange. I mean, how would Harvey track the number of days and hours he worked if he didn't even clock in and out? And plaintiff is alleging that Harvey and the corporation had absolute control over his schedule and activities. Plaintiff is claiming they willfully failed to pay him overtime wages. Number 17, did Harvey deny that? Yes, he also denied that. 17, plaintiff was paid without cash or paid with cash without pay stubs showing information about the actual number of days and hours worked, wage rate paid, employee taxes withheld, etc. 18, defendants fired the plaintiff on or about June 15, 2022. So again, Harvey denies that. You'll see later he claims that think he claimed that the plaintiff quit. This one, that Harvey was a owner-manager, that he's liable. They denied that. And number 20, he seeks to recover unpaid overtime hours weekly for every week he worked for defendant, liquidated damages, and any other relief. He says he doesn't have enough information to admit or deny that. Okay, so deny. He's just denying all these allegations, which we went over in a previous live stream. So I'm not going to just read this whole thing, but we'll scroll this a bit slowly so people can see it. So I mentioned this before, but it does sound a little sketchy to me that plaintiff does not have time and payment records, but he will provide a reasonable good faith estimate based on his recollections and to the best of his knowledge. Sure, I'm sure after all these years when he didn't even clock in or out, I mean, what were his records? Okay, so he's claiming he has owed $11,100. But he's also potentially entitled to attorney's fees and more than that as damages based on the law. Okay, so of course Harvey's going to deny all these things about defendants willfully and intentionally refusing to pay him overtime wages. So let's get back to Harvey's answer. So this is where it gets a little bit more interesting, the affirmative defenses. He says that plaintiff's claims are barred in whole or in part by all applicable statutes of limitation. He claims he was employed since October 15, 2008, but didn't file the case till February 29th, 2024. So his claim is barred. And it's nice to say that, but I think he can still go after the wages for the time period that is not past the statute of limitations. Second defense, any acts or omissions were not willful, but occurred in good faith with reasonable grounds for believing defendants were in full compliance with the Fair Labor Standards Act to the extent it applies, if at all. As such, the statute of limitations can be no longer than 2 years. That's interesting. Third defense, plaintiff's claim are barred as to all hours during which plaintiff was engaged in activities that were not compensable work under the FLSA and were not integral and indispensable parts of his principal activities, including non-compensable activities that were preliminary or post-preliminary to his principal activities. Fourth defense, to the extent that plaintiff is found to be non-exempt for purposes of the FLSA's overtime requirement, defendants assert that any insubstantial or insignificant periods of recorded working time beyond the scheduled working hours, which as a practical administrative matter cannot be recorded precisely for payroll purposes, are de minimis and may be properly disregarded for payroll purposes. Okay, they're saying he wouldn't be entitled to payment anyway for bona fide meal or rest periods, 30 minutes or longer. He can't recover both liquidated damages and prejudgment interest in an action arising under Fair Labor Standards Act, as this would represent a double recovery. Okay, I don't know enough about the specifics to give an opinion about that. They should get a credit for amounts overpaid to him in the course of his employment, as well as credit for overtime and other premium payments already made to her. Okay, well, that's definitely a typo because the plaintiff, as far as I know, is a him, and I don't think you can get credit for what you might have already overpaid to the person. I mean, we're talking about someone who stopped working for Harvey or his company 2 years ago. So just my opinion. Doctrine of unclean hands. They say that, let's see, this is also another typo where it says defendant's actions caused. I'm sure they mean plaintiff's actions caused or contributed to the damages alleged. That's kind of like a catch-all defense, is to say that under the doctrine of unclean hands, the plaintiff did something bad, so they shouldn't be able to benefit from the lawsuit. So just a very general definition. So it says here, plaintiff breached his fiduciary duty to defendants by stealing money owed to defendant 519 in the process of collecting rents and security deposits. Harvey alleges that Danny Tijero also made numerous fraudulent misrepresentations to the defendants throughout the course of his work for defendants regarding, among other things, his whereabouts during work hours. For example, lying about being on site when he was actually in another location and the status of assignments due to be completed. That's interesting. If they knew about this, then why wasn't he fired earlier? Okay. Defense plaintiff may not recover liquidated damages because defendants acted reasonably and in good faith. I'm not sure if there is some sort of good faith defense for these claims. Usually ignorance of the law is no excuse. So here Harvey is claiming that he had a good faith basis to believe that Tijero was an independent contractor or an exempt employee. Okay, I don't think that's a good defense. Okay, 11th defense, can't state a cause of action upon which relief may be granted. I mean, the court already ruled that the motion to dismiss has been denied. So this is kind of strange to throw that in there again. Reservation of rights, they reserve the right to raise any additional affirmative defenses as it becomes known. All right, let's remove that from the screen. And just for people who care about learning more about the law, let's take a look here. This is the Rule of Federal Procedure number 8, which has to do with general rules of pleading. And it does state specifically what are affirmative defenses, which you have to state in your response. So looks like Harvey's attorney kind of exceeded what really needed to be stated as an affirmative defense, but that's no big deal. So the ones that do have to be affirmatively stated are court and satisfaction, arbitration and award, assumption of risk, contributory negligence, duress, estoppel, which in general means that somebody acted or misled another person to believe that something was the case to their detriment. Failure of consideration, that's like not giving somebody something in exchange for an agreement. Fraud, illegality, injury by a fellow servant. Okay, laches, which is unreasonable delay, license, payment, release, res judicata, which means the matter was already ruled on or decided somewhere. Statute of frauds, which has to do with things that are required to be in writing. Statute of limitations and waiver. Okay, so you can find this online if you really wanted to hear about it. So let's just take a look here at Harvey's attorneys. Okay, his first attorney was, from what I've heard, was his longtime friend, Gary Cohen, who is in Coral Springs or Coral Gables. This is a nice looking website. Well, anyway, Mr. Cohen has focused almost exclusively in medical malpractice. For his entire career, he's nationally recognized. So in general, it's usually not a good idea to represent your own friends and family in court. So I think it was probably a good idea for Gary Cohen to decide not to represent Harvey anymore. He was probably doing it pro bono, maybe, just a guess. So instead, the new attorneys are Christopher Lomax and his young associate. So Chris Lomax, the website is lomaxlegal.com. Also a very nice website, and makes me feel like I really need to spruce up my own website. So he started working at the Civil Rights Division of the US DOJ, so that's pretty prestigious. He graduated from the University of Miami, and just like his associate, he clerked for a federal judge, and also worked for Jones Day, which is a very prestigious corporate, huge law firm. It also kind of has a reputation of being a revolving door like most huge corporate law firms. So it's not surprising that he decided to jump ship and go out on his own. And he's also an adjunct professor at University of Miami Law School. He's on the teaching faculty for Harvard Law School's Trial Advocacy Workshop. So it sounds very, very prestigious, like a real top-notch lawyer. I don't see anything here specifically about him doing labor law. He mentions that he did help individuals who he prosecuted people who committed hate crimes and human trafficking offenses. So along with that University of Miami connection, it gives me the feeling that he probably knew Wendi somehow. Looks like he might be a couple of years younger than she is, but perhaps Wendi had this connection and put Harvey Adelson in touch with this attorney. So very impressive. Looks like he's done lots of community service. He's won awards. He was the commencement speaker at University of Miami School of Law. That's great. Okay, so let's look at the associate attorney working on Harvey's case, Brianna Hathaway. So this mentions complex commercial litigation, class actions at the previous big law firm. Did some pro bono work, civil rights, human trafficking, hate crimes. She was a clerk for a federal judge in Florida, and she did her undergrad at University of Miami, JD, NYU. Okay, so very prestigious also. Okay, so I don't see anything about doing employment or labor law, but I'm sure they'll do their best to represent Harvey well. Okay, so my voice is shot. I gotta stop talking and need some more hot tea and stuff as always. Thank you guys for your continued interest in this case. And oh, before I forget, let me also show this, which is the, okay, where was that? Okay, that's where it was. So this is coming up real soon on Thursday. Okay, so it says here that the parties picked Jason Onecki, Esquire, to be their mediator. And the mediation will take place July 11th, 2024 at 2 p.m. via video conference. Okay, so that makes it a little bit easier on Harvey Adelson since he did just turn 80 last week. It's usually less pressure filled if meetings or court hearings or mediations are done by WebEx or Zoom instead of having to hustle and go down to the courthouse or some sort of formal conference room and be trapped there all day. So that does seem kind of unusual to me because most of the time people do discovery for quite a while, for months before they would even schedule a mediation, because in order to be better advised for mediation, you want to see what proof the person has and what evidence the defense has to be able to assess how strong the plaintiff's case really is. But I'm not sure if any discovery has been sent out yet, but of course that didn't have to be filed with the court. So I didn't see any notices of depositions. So perhaps Harvey and his attorneys decided, let's just go ahead and try to nip this in the bud as soon as possible. Let's go ahead and mediate. You can always resume mediation later if it doesn't get you anywhere. So this makes sense. And let's see if the case does settle. Of course, if it does settle, chances are that it would be a confidential settlement. So we probably won't know if this guy gets any money or not. So anyway, that's pretty much it for today's quick update on Harvey Adelson's federal court lawsuit. In terms of Donna Adelson's case, we have her case management hearing coming up on July 22nd in the morning, and that should be live streamed on Deep Dive True Crime. So have a great day. Thank you for still tuning in and still caring about this case.